Ay, di ba?
Ba't hindi
Ah,
binigay sa
di ba
akin ng
ganun?
kanina? Mayroon sa Victoria.
Good afternoon, Attorney Te. You've been part of this Supreme Court family
Good afternoon, Justice
as
Gaelan.
a spokesman during the watch of then Chief Justice Lourdes Sereno. So I'm sure you have a full grasp of the of how the court thinks. So may I just ask you some or a few questions? Okay.
With pleasure, Your Honor.
Okay. Let's go to the issue again of separation of powers, being a part then of the judiciary. Would you agree that when courts supplant their own wisdom to a legislative act under the guise of judicial review, the same is tantamount to judicial legislation?
Your Honor, the parameters that the Constitution has have set for the courts to exercise its power under Article 8, particularly Section 1, are clear, Your Honor. So when we do say that the court acts pursuant to its powers, it is not a case of the court supplanting its judgment or wisdom. I would recall Angara versus Electoral Commission, Your Honor, where this court interpreted it as not a supremacy of the court, but a supremacy of the Constitution, Your Honor. So the constitutional architecture allows this court to act in a particular way. For so long as the court acts within the powers, the parameters that the Constitution defines, then it is not a question of supplanting, or it's not a question of judicial legislation, Your Honor.
But do you think that judicial review, if abuse, would erode the people's confidence in the delicate system of checks and balances and tip the scales to one side in derogation of the separation of powers?
And well, Your Honor, unfortunately, because this is the Supreme Court we are talking about, uh, I am at a loss as to how someone can accuse the court of abuse, Your Honor, because you are the final. This court is the final resort. If the court makes a pronouncement, Your Honor, on what the Constitution means or what the law means, that is what the law means. That is what the Constitution means, and everyone is bound by that. We may disagree. We may agree. We may disagree with the court's opinion, but that is the court's opinion, and that now becomes the interpretation of the Constitution or the law in relation to the facts presented, Your Honor.
So given the framework and wording of the Constitution and its contemporary interpretation, do you think it allows for the judiciary to take an active role in public policy formulation? If
In,
so, do you think the exercise of judicial review in this context violates the doctrine of separation of power?
I do not believe it does, Your Honor. I would call to mind Article 8, Section 1, particularly Paragraph 2. The last portion of Paragraph 2 does give the court the expanded jurisdiction to inquire and act upon grave abuse of discretion by any branch, instrumentality, or agency of the government. And by branch, Your Honor, we would refer to the two other branches of government, the executive branch and Congress, Your Honor.
Okay. Yes, the expanded definition of judicial review in the 1987 Constitution explicitly contemplates constitutional judicial review.
Yes, Your Honor.
In your opinion, does the 1987 Constitution allow an a priori or an ex post facto review of legislation?
By ex, I'm not sure, Your Honor, what we mean by ex post facto, after the fact. Well, every review, Your Honor, comes to the court after the fact, after the Congress passes a law. But I would suppose, Your Honor, if we were to say a priori, meaning before someone is charged, then yes, Your Honor, this court has allowed, Your Honor, challenges like those. And I think that is what we would call facial challenges, Your Honor, on
Yes.
to the law itself.
American common law, which our tradition adopted, favors ex post facto constitutional review, while continental Europe or the civil law tradition, which has likewise found its way through our civil and penal law, favors a priori constitutional judicial review. Would you agree that the creation by this body of exceptions to requirements that an actual controversy is present, such as transcendental importance and matters capable of repetition but evading review, have made the court vulnerable to institutional attacks due to its penchant for meddling in political affairs, which are rightfully in the realm of executive and legislative power?
Your Honor, allow me to answer your question in this way. The court, the Supreme Court, operates within a particular context, and the context may change, Your Honor. And so the call for the court to act will depend on the context, Your Honor. So there may be times when the court may be called upon to exercise restraint, but there may also be times when the court is called upon to more actively exercise its powers, Your Honor. So on that point, Your Honor, I think it would really depend on what is before the court and what is the context of the argument that is being presented to the court, Your Honor.
So, what, in your opinion, is the value of judges exercising judicial restraint? Do you favor a liberal approach to interpreting what judicial power is in the Constitution?
Well, Your Honor, my personal bias, Your Honor, would be civil liberties and human rights. And so I personally, Your Honor, my personal bias is a more
Being
is
formerly a member of the Supreme Court family.
well, Your Honor, when I was working with the court, Your Honor, I was not in the adjudicative aspect of the court. But again, Your Honor, my personal bias on civil and political rights and human rights, Your Honor, would be that the court be more progressive in terms of its actions and its decisions. But in relation, Your Honor, to other issues, Your Honor, I believe there are grounds for the court to exercise judicial restraint, Your Honor.
Now, in your opinion, Attorney Te, has this court in the last 3 decades exhibited activism or restraint in examining constitutional questions such as those now before us?
I might call it, Your Honor, peaks and valleys, Your Honor. There were certain decisions where this court, exercised activism, again, given a particular set of facts. As for example, Your Honor, I think it has been mentioned before, David versus Arroyo. There have also been instances, Your Honor, when the court did not take action when, again, I speak personally, in my opinion, the court could have acted.
So, would you please indulge this court to draw a line when a court exhibits judicial activism and when a court has become politicized? To this end, would you agree that judges tend to be political, especially when they are confronted with questions of policy?
Well, Your Honor, I would not be so presumptuous as to draw the line. I would point to the Constitution, Your Honor. Article 8, Section 1, Paragraph 2, particularly the last portion, Your Honor, grave abuse of discretion. I think that is a standard that is well known to the court, and that is a standard, Your Honor, that the court has applied repeatedly. There are various tests that the court has used, Your Honor, in relation to its power under Article 8, Section 1, Paragraph 2. I believe, Your Honor, that would be a line. It may not be the only line, but it is one very important line because it is what the Constitution has drawn, Your Honor. So I believe, Your Honor, if the court is looking for a balance, as it were, when it should go against or it would be more political or when it would restrain itself, Your Honor, I think the Constitution has written that line. And that line would be grave abuse of discretion, a showing of grave abuse of discretion on the part of a branch, instrumentality, agency, or government, Your Honor.
Now, this is a personal question. You can answer or not, Attorney Te. Why did you leave Supreme Court family?
Your Honor?
Why did you leave?
Your Honor, 2018, Your Honor.
Why?
Well, I believe that my work here had been done, Your Honor.
Okay. So the judiciary has time and again been embroiled in skirmishes with Congress and the executive. Questions on fiscal independence of the judiciary and even impeachment of these court's members have become rather common in the last decade or so. Is there a relationship between the attitude of this court towards judicial review, both constitutional and administrative in nature, and its dealings with the two other branches?
Well, unfortunately, Your Honor, impeachment is a political tool, Your Honor. And it is a tool that is also a constitutional measure that is provided in the Constitution. And unfortunately, Your Honor, politics being politics, Your Honor, it is defined by the person who wields the tool. So if you were to ask me, Your Honor, whether there is a relationship, again, it depends on the one who is wielding the tool, Your Honor.
Now, let's move on to the violation of fundamental rights. In the hierarchy of rights, would you place freedom of expression above the rights to peace, safety, and security?
Your Honor, that is what the court itself has said. Your Honor, that freedom of expression occupies a preferential right. In fact, it is oft repeated as to be may perhaps be canonical already, Your Honor. That as for example, when a law transgresses on its face a right like freedom of expression, then it comes before the court bearing a heavy burden of unconstitutionality, and the burden is not on the petitioners; it is on the state.
Okay. Now, would you agree with me that advocacies, protests, and other exercises of political and civil rights which actually causes death or physical harm is different from said acts which are intended to cause death or physical harm?
Certainly, Your Honor. There are acts that even if they are defined as rights, if these acts would already transgress, Your Honor, into what the penal law would define to be an offense, whether a felony or special crime, then yes, certainly, Your Honor.
So relatedly, intention can be gathered and surmised from the attendant circumstances surrounding such exercise of political and civil rights, correct?
Yes, Your Honor. The intention is generally inferred or divined from the overt acts that are performed, which overt acts would be defined, Your Honor, into either a felony or a special law.
And that if this exercise of political and civil rights are intended to cause death or physical harm or endangers a person's life or creates a serious risk to public safety, it will fall under acts of terrorism under Section 4, correct?
That is how Section 4 defines it, Your Honor, but we disagree with that, Your Honor.
If, for example, an individual during a rally protesting against a legitimate cause went on the stage with a megaphone, started to chant, encouraging other individuals present to cause destruction to public property. In the foregoing instance, is the individual violating Section 4 or Section 9 of the ATA?
Well, Your Honor, that is one of the nuances in the law that is unclear, Your Honor, because it looks like it may, based on how you gave the facts, Your Honor, it looks like it may be a Section 9 violation, but at the same time, Section 9, Your Honor, cannot be committed without Section 4.
If the individual with the megaphone does not directly take part in the acts of destruction, would his acts constitute terrorism under Section 4 or Section 9 of the ATA?
It would be Section 9 because Section 9 makes it a specific element that the person does not take part, Your Honor.
Now, if instead of acting on the speaker's directives, the other individuals present started booing the speaker and heckling him off stage, did he commit a crime with the attempt to encourage the destruction of public property?
Well, Your Honor, I think we would have to look at the effect of the booing or the heckling, because the last part of Section 4, for example, Your Honor, the purpose, context, nature, would refer to very specific parameters, Your Honor. Was there fear, intimidation? Was there undermining of government? And so that would have to be interpreted within that particular context, Your Honor.
Now, the Section 4, you attack the provision as void for being vague, as it punishes intent, nature, and context. Among the key arguments raised is that intent is a state of mind, that law enforcers will not be able to determine one's intent to commit the acts punished. Are there other crimes in our jurisdiction that punish the intent of a person?
There are none, Your Honor. The crimes that I am aware of, which would include felonies, Your Honor, punish a specific overt act where an intent is prescribed or an intent can be inferred or divined, Your Honor.
Precisely, like Article 172, falsification by private individuals,
Yes, Your Honor.
use of falsified documents, even frustrated homicide and murder punish an intent to kill,
Yes, Your Honor.
on contrast to physical injuries.
Yes, Your Honor.
In these instances, the law likewise punishes a state of mind, but this does not by itself make the law vague as to lack comprehensible standards that men of common intelligence must guess at its meaning or lead to an arbitrary
No.
flexing the government's muscle, right?
No, Your Honor, they do not, because it is pretty clear what is being punished, Your Honor, and why it is being punished.
So can the determination of the intent and the purpose of the suspect be left to the judges in the individual cases filed before them?
Well, Your Honor, that is the work of the judiciary, unfortunately. But what is more disturbing here, Your Honor, is that the determination of the intent and the lawfulness of the act that is being performed, Your Honor, is being left at the first instant to law enforcers, Your Honor, without discernible standards. And that is where the danger comes in. Because a law enforcer, Your Honor, taking a look at a particular situation may arrive at one conclusion. Another law enforcer looking at the same situation, Your Honor, may arrive at a totally different conclusion. And so, Your Honor, it would be a case of your opinion is as good as mine. But, Your Honor, for purposes of criminal law, for purposes of constitutional law, that would not be acceptable, Your Honor. That is where the vagueness comes in.
So-
And if I may also add, Your Honor, that is where also the problem of overbreadth comes in, Your Honor, because it may include, from the point of view of the law enforcer, a legitimate lawful exercise of a right.
So do we not have sufficient standards under the rules of court and jurisprudence that provide guidelines in assessing intent?
Unfortunately, Your Honor, the law must be complete in itself. The law must provide for the standards. The law does not, Your Honor. The law simply says in Section 4, acts intended to, Your Honor, and that is a whole universe of acts, Your Honor.
Thank you, Attorney Te.
Thank you, Your Honor.
Thank you, Chief.
Justice Rosario, do you have some question? Okay. We will finish the interpellation so far as the petitioners today.